everyone. Good afternoon. My name is Rich Williams. I'm here with Tyler Wetering from Gunderson, Palmer, Nelson, and Ashmore firm. Tyler, could you introduce yourself for us?
I am Tyler Wetering. I'm a partner at Gunderson Palmer, and Rich and I are the members of the firm's cannabis law section. We're going to provide you guys with some basic overview and some information on the recent ballot initiatives and constitutional amendments that South Dakota recently passed.
So as you notice from the screen, we've identified our little webinar today as Cannabis 101. It's just going to be a quick overview of the new laws in South Dakota. But I would like to start with a disclaimer. During this webinar, we are not intending to provide legal advice to you. If you'd like legal advice on this topic, please call our office and we'd be happy to provide that. Moving on, as you'll probably notice, if you've seen in the papers, you've heard on the news, we've had a couple new changes in South Dakota law regarding marijuana. Those came in the form of IM 26 and Amendment A. Both of these measures were initiated by the people of South Dakota through petition. You'll probably notice you saw them on the November 3rd ballot of this year. On November 10th, the Secretary of State confirmed by statewide canvass that they in fact became law. If you'd like to see the full text of those measures, you can find them on the Secretary of State's webpage. And we have a site there at the bottom of this slide. So IM 26 was basically a statutory change to South Dakota's laws. And that's different from Amendment A. Amendment A was a constitutional change. And we'll talk about the differences and the reasons why that's important here in a little bit. But IM 26, the statutory provisions, basically, and I'm paraphrasing here for much of this, it legalizes medical use of cannabis by qualifying patients. It includes the manufacture and cultivation of cannabis for medical conditions, and it is administered by the Department of Health. Amendment A, on the other hand, is our constitutional amendment. And this is important because this actually amends South Dakota's Constitution. So whatever the legislature does in the future, will have to conform with Amendment A. The legislature, of course, can change IM 26 during its legislative session because it is merely a statutory change. Amendment A, for the most part, legalizes adult use of cannabis within South Dakota. And that includes the possession, use, transport, and distribution of cannabis by people aged 21 and over. It additionally allows individuals to distribute 1 ounce or less of cannabis without consideration and allows the growing of cannabis under certain situations. Amendment A is going to be regulated by the Department of Revenue once it's put into effect. Tyler, can you tell us a little bit about what Amendment A does not do?
Sure. So like Rich said, Amendment A authorizes the adult use of cannabis by individuals aged 21 and older. But what that amendment does not do is affect any of the laws for individuals under the age of 21. So meaning for those individuals, it'll still be legal to possess, distribute, ingest, or use cannabis. It also does not affect South Dakota's DUI laws, so it'll still be a crime to operate a vehicle, watercraft, aircraft, anything like that, while under the influence of cannabis. It does not authorize the use of cannabis in a vehicle or watercraft or other vehicle by passengers. So similar to South Dakota's open container laws, South Dakota can't be, or under South Dakota law, marijuana use will not be permitted in vehicles even by passengers. It does not authorize the possession or consumption in schools or other public places. And it doesn't affect a number of other laws, where municipalities will still be able to regulate the, time, manner, and place of the adult use of cannabis. Some other things that Amendment A does not affect is an employer's ability to restrict use by employees, and it does not require employers to make accommodations for the adult use of marijuana by its employees. So employers can continue to prohibit the use of marijuana by its employees. They can prohibit employees from coming to work impaired, just like they could prohibit the impairment employees by alcohol or other substances. They don't have to make accommodations for employees' use under the law. They can continue to drug test and terminate employees for the use of marijuana. So it does not impact employers' abilities to, operate their businesses the way they see fit. And that's something, we've already heard a number of questions about from various employers is, now that this is legal, do I have to allow my employees to use it? Can I prohibit it? Prohibit them from coming to work under the influence? And the answer to that is, you continue to kind of have the same power to exercise control over your employees, just like you did prior to its legalization. Another question we've got asked recently relates to landlords' rights. So as a landlord, either of commercial or residential property, for residential landlords, you don't have to allow your tenants to, you can prohibit their use of cannabis in the residence. You can restrict the, possession by your tenants. And commercial landlords retain kind of the same abilities where just because a tenant leases commercial space from you doesn't mean you have to authorize the use of that space for cultivation, for retail sales, for possession, for use. And then local governments still retain the ability to regulate and prohibit the use in public buildings, which we expect will be the case, just like you can't smoke in government buildings currently, or use alcohol. You won't be able to use cannabis in those spaces or possess it as well, even under the new laws. Rich did indicate earlier that unlike IM 26, where much of the oversight is taken on by the Department of Health, Amendment A directs that the Department of Revenue will regulate and develop regulations related to adult use of marijuana, and they will issue all the licenses and develop all other regulations that are going to be necessary under Amendment A. And we'll talk a little bit about the timing on when some of these regulations will be developed. But essentially what Amendment A does is it lays out 4 broad categories of licenses that will be issued by the Department of Revenue. That's licenses related to cultivation, licenses related to, I should say cultivation, manufacture and processing, licenses related to testing facilities, licenses related to the wholesaling of cannabis, and then a 4th set of licenses for retail sales for cannabis dispensaries. The rules are to be put in place regarding these various licensing criteria by April 1st of 2022. So, we anticipate during this next legislative session, there will be some, potentially some groundwork put in place that will authorize the Department of Revenue to put in place its rules for the various licensing structures that will be put in place. But beyond kind of the 4 categories of licenses, there's not a lot of real clear guidance in Amendment A in exactly what those licenses will look like. So there's going to be probably a fair amount of opportunity for individuals and entities to put input as to what this licensing structure should look like. Because while we have kind of a general framework from it provided by Amendment A, it did not go into the detail of exactly how these licenses will work.
So to dovetail quickly off of what Tyler said with regard to the implementation of Amendment A, as a constitutional amendment, it's going to be at the top of the food chain with regard to the law. After that, you're going to have the statutes, and below those statutes, you're going to have administrative rules. So this legislative session, I think what you're going to see is the flushing out more of how Amendment A is going to work, the types of duties and authority that the Department of Revenue will have, and they'll also probably be given administrative rulemaking authority in that process. And then the Department of Revenue then will actually fill out the statutory authority even further. So you're going to have your constitutional level, your statutory level, and then your administrative rule level. And we've yet to see, and until this session's over, or maybe even the next session, how much that's filled out and what that means for you. And as regard to licensing, regulations, and rules, we're going to have to see how that all comes out. But if you would like to have some input in that and do some logging, I would suggest you start now to form those rules at the beginning rather than to be reacting to them later on in time. We move to this next slide here that talks about regulation by local government. And that's an important subject under Amendment A because local governments can prohibit the licensees that the Department of Revenue would authorize from operating within their jurisdictions. What happens if that occurs then? Well, under Amendment A, it allows individuals to grow a certain amount of marijuana and store that cannabis at their locations in locked rooms under certain conditions. But it's probably preferable that these items be regulated by the Department of Revenue. And if they are, the city can, or city, township, or county can allow for different types of zoning. And what that may look like is really up for debate. It hasn't been accomplished yet. I think that municipalities and counties are currently, looking at how this would operate within their jurisdictions. But you might see zoning where, okay, we want, let's say, cannabis retailers located here. We want, manufacturers located here, packaging, all that kind of stuff needs to be sorted out. The issue with that is, of course, if you're looking at getting into a cannabis business, you might want to go ahead first and speak with representatives of your local government, and certainly your representatives that are going to be in the legislature this year, because what you want to ensure is that your location that you choose will actually allow the type of activity that you're proposing, whether it be growing, packaging, or retail sale. So definitely want to start looking at your options for the type of business you want. Get in touch with your local representatives and see where they're at on this. Get your ideas known to them now. Like I said earlier, get ahead of this and determine, so you can help shape this rather than reacting to it later. And that goes to the next slide with the next steps for local government. And again, as I talked about this, you're going to have your municipalities. I don't know if any of you or many of you have been involved with the legislative process. Some people compare it to making sausage. There's a lot that goes into it, and you might not get a product coming out that looks like it did when it went in. But what I would suggest is the input is very important. And in this instance, local governments, I think, are going to be a large reason for the way that the law looks. And that's why I suggest if you do want to set these things up in a way that you want to see it happen in the future, to talk to local governments. They will have representation there to speak with the legislature, to the people in the legislature, and to help form those laws as they're being made. You also may want to look for a private lobbyist to help you out in that regard too. If you have an individual or a company that's looking to, try to conform the laws to the way its business practices currently work, or they want them to work. And this legislative session is going to be interesting. like we've talked about, we don't really know what's going to come out of this. What we do know is that Amendment A itself cannot be changed without another constitutional amendment. However, I would note that there is a current lawsuit challenging Amendment A. However, Amendment A is going to be considered constitutional and it's going to be given that presumption until a judge rules otherwise. So I would move forward as if Amendment A is in fact going to be the law of the land after that lawsuit. So, sort of summarizing, I think the main things to be looking at are how do you want to participate in the new cannabis business within South Dakota? Do you want to participate at all? Are you for it? Are you against it? But if you are looking to engage in it, I would suggest getting out early, getting out often, and helping work with others that are interested in doing what you want to do. Start at a retail level, starting at your local level, and obviously going to the legislature. So there is the occasion where local government could ban, like we mentioned, all licensees from operating within their jurisdictions. That is a possibility. That's why we suggest if you want to ensure that you can operate a business that you want in that area, get out soon. Tyler, what else do you have for us on this topic?
Yeah, and I think that's a great point, Rich, that early involvement, especially on the local level, is going to be kind of integral to this. Not only to make sure that your town, your city, your county authorizes the retail sales, the cultivation, all these different activities that the department will develop licenses for. You want to make sure that that's going to be permitted in the area that you want to operate your business. So getting involvement with that local government's going to be integral to making sure that you're able to operate your business the way you want to and in the location that you want to be in. The other kind of component to that is, and like I mentioned earlier, we don't know what these licensing arrangements are going to look like. But one component of a lot of these licenses and structures in other states that either have adult use marijuana or medical marijuana or both is, in order to get these licensing or get a license to operate within a jurisdiction, you have to have some show of local support. So whether that's a letter of support from a local chamber of commerce or the mayor or the county commission or whoever it is, a lot of these licensing structures contemplate having some level of local support just as an initial threshold to bear or to meet before you can gain a license. And these licensing structures have been really varied in the different states that have adopted either adult use or medical marijuana. So it's not clear in South Dakota, what our structure will be like, whether it'll be something that's, vertically integrated, where you'll have to hold, all 4 licenses or be able to hold all 4 licenses in one vertical structure or by one entity, or whether it'll be, handled similarly to, how South Dakota's alcohol industry works, is where you're prohibited from holding, more than one license. You're either a wholesaler or a retailer, or a producer, but you can't be all 3. Some of the other things that some of these other states have implemented is, either for cultivation licenses is either canopy minimums or maximums, meaning that if you have a cultivation license, you have to have, X number of square foot in capacity, or you're limited to, an upward limit. And there's, advantages and disadvantages, I think, mentioned by both sides or supporters of both sides. The other thing that a lot of these jurisdictions do as far as licensing is, in order to gain a license, whether it's for retail or cultivation, you have to show that you have access to, X number of dollars in capital. You know, and a lot of this is all designed around making sure that there's adequate supply to meet demand and to curtail, you know, the illicit production or growth of marijuana, or the unregulated growth of production of marijuana, but not too much where there's too much supply, you know, and not enough legitimate demand where, you know, there's sales out the back door or anything else, just because there's, you know, kind of a glut of these products, you know, in the market. So it's definitely a balancing act in determining, you know, what licensing structure and what various requirements make the most sense from a public safety standpoint, from a public health standpoint, and from a business standpoint as well. So there's going to be a lot of potential, you know, for variation or differing opinions on what this licensing structure should look like. And, you know, South Dakota is kind of in a unique spot where we're the first state that's has not had a medical marijuana infrastructure in place before we authorized adult use. So it's kind of uncharted territory here for what these things are going to look like, how that infrastructure is going to be developed, you know, and who's going to be able to obtain licensing. But it's definitely a situation where maybe individual input, you know, from the outset is going to be more important here than it has been in any other state that's authorized adult use marijuana. And I think Rich touched on the recent litigation, and I think that's, you know, one of the last items we had on the slide, and one of the last items we had in our PowerPoint. But I'll let Rich give any last comments he has on that litigation or anything else.
Well, Tyler, we talked about this offline a little bit, and you mentioned the different licensing structures. Are there certain structures that favor like a mom and pop operation versus a large corporate operation?
Yeah, and a lot of that's going to be, you know, geared towards, you know, either canopy minimums that, you know, a small, you know, mom and pop, as you call it, might not have the space, might not have the infrastructure, might not have the capital to put in place, you know, a large scale indoor cultivation. The other thing is, you know, the capital requirements. Obviously, if you're a state like, you know, New Jersey, I think in their medical marijuana, you had to show that you had access to something like $15 million in capital. Well, that, you know, severely limits the you know, number of individuals that can meet those qualifications. I don't think something, you know, like that makes sense in South Dakota. And, you know, I think Constitutional Amendment A, while it is a little bit sparse on details on exactly how these licensing or how these licenses will be structured, it does seem like it. The intent is that you know, it be geared towards maybe smaller in-state local growers, you know, who might not have access to the capital that some of these out-of-state ventures might have. So there's, you know, definitely advantages and disadvantages to both. But there's, you know, like I said, it's pretty up in the air right now as to what those structures will look like.
Well, I guess that's another way of saying, hey, if you're interested in getting into this and you want to see how the structure is going to be formed, get in early so that you're not stuck with whatever comes out on the back end of it.
Right, absolutely. I mean, we don't know, you know, what these things are going to look like, but there's now's the time to make those decisions, and these are when those decisions are going to be made of what that overall structure looks like. So the ability to advocate for one position or another's, you know, your ability to do that's never going to be greater than it is right now.
Well, thank you everybody for participating today. We have a thank you slide here at the end, and then if you need our information, you can find it. We'll flip back to that first slide in the presentation. Find us at www.gpna.com, and you can contact us that way if you have any further questions. Thank you for being with us today.
Yep, thanks very much, everybody. Appreciate you guys taking the time to join us.